we, in view of the conduct of the petitioner, we call upon him to submit an explanation why action for contempt of court should not be initiated against him for judicial contempt.
My Lord, it would be civil contempt, my Lord, this disregarding of the court order under section
for क्या उसको कहते हैं? नहीं, for contempt लिख देते हैं वो under the contempt of court ordinance, 2003, read with Article 204 of the Constitution. Stop. The learned judge, acting in undue haste and at the 11th hour, that we saw the list, that the learned counsel went through the list of returning officers appointed pursuant to the 4 notifications and stated that they were all, that in one of these notifications pertains to the officers of the ECP, whereas the remaining 3 are all serving government servants who already were holding their respective positions and have not been put in place for the purpose of this election or on anyone's behest. Stop. The petitioner before the High Court also learned counsel further states that that initially the ECP had pursuant to section 51, pursuant to
50 subsection 1 clause C and 51(1)
and 51 within bracket 1, written to the Chief Justices of the 5 high courts and requested them to provide judicial officers for the upcoming elections, and not a single one of the Chief Justices agreed to do so. He has referred to a letter issued by the Lahore High Court, which specifically stated that letter किस पेज पे था?
211 to 10 से 211 210 2210 6th of February.
नहीं वो आपका नहीं, the reply.
Reply. 210 to 211.
Emphatic reply was given that no judicial officers can be spared because there are over 1.3 million cases requiring adjudication.
Approximately.
About 1.3 million cases requiring adjudication, and delaying and provision of such officers would result in the tendency to increase and of which the ultimate sufferers would be the litigants. Stop. Under such circumstances, for the petitioner to insist on judicial officers to be provided would effectively mean that a writ be issued against the High Court which is not permissible under Article
199.
199.
Clause 5,
Clause
sir.
5 is
199 clause 5. But this is the Chief Justice.
And in this regard, place his reliance upon the case of Gul Tez Khan Marwat. यही है ना?
You have to come to the Supreme Court.
And versus Registrar Peshawar High Court, PLD 2021, Supreme Court 391, which was a judgment by a far member bench of this court. इसमें हमने क्या किया?
इसमें कहा कि reputed नहीं है कि High Court के against.
हाँ?
That becomes a wonderful thing. The only remedy in such a case, according to this judgment, is to approach this
court.
And it was held therein that since the only remedy, that if at all there was any remedy, it would be to approach the Supreme Court of Pakistan, which judgment appears to have also been disregarded both by the petitioner as well as the learned judge who passed, the learned single judge. Full stop. Under the circumstances, it would be appropriate to we hereby direct that
What's the number of the petition?
The High Court petition, it's
rate petition number 80828 oblique 2023 be
what? Yes.
be called from the High Court should not take any further proceedings in WP number 80828 oblique 2023, and the same be placed before and the same be sent to the Supreme Court, and if it is deemed necessary, this court will fix it for hearing. Before this court, full stop. In view of the fact, ordinarily, this court does not pass. It does not suspend orders without issuing of notice, but in view of the fact, but in view of the